examination. The education matters come to learn what was happened on that case. There was single bench order, division bench order, relegated to expert committee. Expert committee filed a report. From there, I have here. When the expert committee report was filed, the other honorable single judge at page 142.
Is it related to the items which is coming up on 15th?
That is a different issue.
Oh, yes. That is, they are accepting the report and saying that 1 mark is left, so give me the 1 mark so that we can complete. We are here challenging the entire report.
No, I have placed in the morning, one of the advocates have mentioned, I have placed that writ petition on 15th. Since case and counter case means you are someone are accepting, someone are rejecting.
No, probably, may I?
Yes.
The committee's report, the expert committee's report filed before the Justice Honorable Single Judge Justice Basu, since as is of CTN was. Expressly, his lordship in his order said that now the report has come. So the part your prayer was that there should be a specialized report. So your petition is informed. If you are agreed with the report, you can take recourse to other petition. That's the express liberty granted. Invoking that liberty, I am before my lord. I will point out to lordship, these are the questions, these are the answer. This answer, the expert committee's report is, my lord, non-est in the eye of law.
So let us take it up on 15th, along with those. Mr. Dasgupta is there. He mentioned the matter.
What we have challenged, my lord. The expert committee says that there is a printing error in the question.
Oh, only that part.
I have said that yes, there is a printing error. According to the expert report, you award me marks.
No, just tell me one thing, that whether this writ petition has got any relevance to the matters which is coming up on 15th.
I think
no. I think, my lord, here, my
because
lord,
all is concerning the report filed by the expert committee.
That
correct.
Petition is also concerning the report filed by the expert committee.
Now you accept that portion which supports your case
yes.
of having 1 marks extra so that you qualify.
I have no problem to that.
Yes.
If that your lordship decide that there is an error on the report itself and they should get 1 mark, I have no problem. But I am saying the other Supreme Court says in the writ court it can be decided. If the report is erroneous, then the conclusion will be otherwise.
In the present writ petition, are you seeking for a fresh inquiry report to be submitted by setting aside what is been filed?
Be praying for setting aside.
If that is set aside, then it affects the rights of Mr. Dasgupta's client because he is relying on that report to have 1 marks.
No, to that extent where 1 marks has not been given due to admitted one question is wrong.
We take it up on 15th. The joint prayer of the parties list this matter on 15th this application seeking that the report is not proper.
I get your losses.
Has filed a writ petition taking a part of the report. 1 mark should be given to them so that they qualify and take part in the recruitment process. So all these writ petitions, the issue concerns the report.
But my lord, on different angle and point.
Yes, that's true.
So that's therefore, my lord, I want to deal with independently, not collectively.
We start on 15th.
So
you see what is in the report.
No, all that I'm taking in losses. Take it not 15th on any independent day. That's my point. Not collectively.
Then it can be taken up today only.
Do that.
I want to have a glance of the report because it affects the rights of both the parties. Now, if on 15th I can decide what Mr. Dasgupta is saying, if suppose Mr. Basu succeeds in the writ petition, the entire report goes. It affects the rights of the client of Mr. Dasgupta. Yes. He is seeking 1 mark.
Yes.
So, what I understand is that the rights of the parties are pertaining to the report that is submitted.
What my understanding will prevail? Can I take it on 15th?
Mr. Sannal has something to say. You think?
No, my lord, my point is that
he will be arguing independently. Let him argue. Let us
So
also
do it
independently.
today. My lord, I tell you, this will not cover. This will not cover because I tell you, lordships, what he is asking for, kindly have a look at that. Anyway, but your losses, if your losses do not want to take it, but not on 15th,
Not
any
if
other
the,
day.
if the matters are separate, then I can take it up because I have fixed it on 3 p.m. Why should I defer it?
আমার করতে আপত্তি নেই।
Okay, let's see.
In view of such finding of the expert committee in the report, the challenge of the petitioners that there are mistakes in the answer key and questions of suggestions. It is, however, made clear that notwithstanding this order, it is open to the unsuccessful to challenge the veracity of the said report of the expert committee if they are so advised. Invoking this, my lord, we are now before my lord. Challenging the report, this is the entirety.
Yes.
এটা কোথায়? একটা page, that page. Just a minute. One. One of the report is, which is subject matter of challenge is 150. এত মোটা করেছে না।
একই তো volume। No,
না, second volume. 150, my lord, it starts. Has my lord got it? 150 it starts, it continues. My lord need not be troubled at this stage. So far as what are the questions were there, what the answers were, my lord need not be troubled. Kindly come to paragraph 17 of the writ petition. এই একটা ওকে দেখো। Crystallize করে।
You know?
But this is will be based on the pleadings. Kindly come to paragraph 17. This I will place before my lord. I have in this chart, I have just handed over to your lordship. I have made the left hand side, my lord, get the question number. In which page? The board's answer, which page? Expert committee answer, which page? And it is absurd. Why? Last column. If two views are possible, my lord will not intervene. If expert committee says today, I am given an instance. Expert committee says today sun rises in the west. What has ample power to see? No, it cannot. On that basis, I prepared this. The last part is the evidence which your lordship has to adduce, has to my lord consider, and what is the question. But kindly come to paragraph 17. Kindly allow me to place it. Your petitioner stated that there is a serious discrepancy in the expert report which was submitted before the Honorable Court. It is stated that in the upcoming pleadings, the petitioner so-called some glaring examples of questions and their options, which is actually incorrect, but the same is shown as correct or the same is agreed by the expert in the expert committee. It is further stated that upon in introspection and discussing the report, this Honorable Court can find out that there is a serious error, mischief, and such. Now, my lord, kindly come to the question. Your petitioner states question number 136 of question booklet series 048. The question reads as follows: which of the following are horticulture resources? Paddy and jute, mango and lychee, tea and coffee, wheat and mud. It is stated that the answer key of the question supplied by the concerned respondent is B, means mango and lychee. The same was agreed by the expert committee. The aforesaid question was answered as option C by the petitioner, which was marked as incorrect by the such and such. Your petitioner states the textbook, RTIs and the journal shows that option C is also correct, entitling the petitioner for 1 mark. This is our example, my lord, I am giving. Your lordship, kindly come to page 193 once. at the bottom. Is it?
193.
But,
একটু কালচে হয়ে গেছে।
Yes, 193.
can you see which are the following? A, B, can you turn over the page? The expert committee said answer key to the question is B. Have you seen that?
Expert answer opinion.
Next page, 194. This is expert committee report. Answer key to that question B.
B.
B. Now I will show to Lordship the in our suit code we say evidence. What is the evidence? What I am submitting. Kindly come to page 268. আমি educated হয়েছি এখন. But everybody is questioning me why I am educated. 268. Kindly come to page 268.
Yes.
This is my lord Indian Institute of Science, Education and Research, Kolkata. But their opinion is they are the topmost authority. It is written, my lord, in response to an RTI. In reference to a request of information of under RTI Act 2006, this is for your information that the application has been forwarded to the head department of Mathematics and Statistics, IICR Kolkata, and the reply revised from the content is IISR Kolkata is further below. In question 93, both answer B and C are correct, as the usual mathematical interpretations of both are the same.
I have not seen question number 93.
Oh, that is the question? I have
No,
shown just now.
This is question number 136.
Oh, কি লিখেছিস এটা? 268. হ্যাঁ।
ঠিক করে আন,
আরে,
ঠিক করে আন।
page তো 93 এটা question number. এই আমার কাছে নেই কেন? Just a minute, one. This is another 294. কি করেছিস এটা? Just a minute, my lord. I'm sorry, my lord.
Yes.
কি 93 কোশ্চেনের উত্তরটা কোথায়? 268. তুই আমাকে একটা নিজে একটা দেখছিস, আমাকে একটা দিয়েছিস। 270. তাহলে এটা কি দিয়েছিস?
আবার সাজিয়ে নে স্যার, ছেড়ে দেবে।
এই বিরক্তিকর, ওদের কাছে এসে এম্বারাসমেন্ট হওয়া বিরক্তিকর। নট ক্লিয়ার, কি দেখাবো আমি এটা? কি দেখাবো আমি এটা? পুরো কালো। Well, kindly see question number 93. At least one I must convince my lord.
136.
Just now I placed 268.
No, 268 in respect of 93.
No.
হবে না এটা।
একটা করে দিই, একটা they has to reply. Today my lord will not allow or dismiss my written list. 268 is question number 93. Let us see question number 93.
ক্লিয়ার ছিল। কোশ্চেন না।
এটা অলরেডি
93 কোশ্চেনটা কোথায়? এটা তো 93
আর তুই আজকে হতে পারে এটা। It may
What is
happen.
the question 93? আরে 93 কোশ্চেনটা রিপোর্ট, আমাকে এটা রিপোর্টটা দেখা না।
page 200.
এটাই বল না। কোশ্চেনটা কি?
Evaluate the length of the path to describe the regular width by a thousand.
এটা হচ্ছে page number 93. Evaluate the length of the path.
199.
হ্যাঁ।
Well, kindly come to page 199. Now at least one answer I try to satisfy.
Yes.
199.
93
তুমি এবার
99 বার কত?
199.
কি আছে এটা পরে
পড়াই যাচ্ছে না।
199 deals with to evaluate the length of the path described by circular wheel by a complete rotation. We need to evaluate. What are the answer? The area of the wheel, the circumference of the wheel, the measure of the circumference of the wheel, the length of any chord. As well as Kali got it. Answer is, expert says, answer is, next page answer is 200. Answer is C.
B and C both are correct.
So if my client is answered B, whether you will not get a mark. I have pleaded, my lord, from paragraph 17 to paragraph 32. I have pleaded question, answer, expert answer, and the authentic answer. Let them answer to that.
কি আমি এখন বুঝতে পারিনি তুই কি বলছিস, তুই একটা দেখালি আর একটা বললি।
না না একটু 90 দেখালাম দেখো
96
90 পেজ 199 দেখ
হ্যাঁ,
এটা দেখলি তো উত্তরটা
কোশ্চেন
দেখ
নাম্বার কত?
ওই তো 93 উল্টা এবার উত্তরটা দেখো ওখানে কি বলেছে উল্টা না এখানে কি বলেছে সি আর 268 এ বলছে বি এন্ড সি বোথ আর কারেক্ট
268 কে?
ওই এক্সপার্ট
ও আচ্ছা আচ্ছা, আমি বললাম রিপোর্টই বলছি।
না না
ঠিক আছে, আমি বুঝি।
by this process I have pleaded, my lord. It has to be plead, otherwise cannot be proved. 17 to 32 I have pleaded question wise, answer, expert's view, and the authentic view. I given one instance at least to my lord, where the authentic view is both are correct, expert said one is correct. Whether
Yes.
if these are, my lord, what I am submitting it as correct, then my lord report cannot be sacrosanct.
That is all.
17 to 32 all answer has been said in this process. If they have any answer to this, let them give the answer. It is shortest possible time because recruitment process starts. Even if I succeed, my age, somebody's age will be out of age.
Yes, Mr. Son.
I am not citing any judgment.
No,
The proposition that you will not can do into this question. If the textbooks will prevail, textbook will prevail. এটা কি লিখলি?
ও ওকে একটা কপি দাও। No, I just give the chain of history. That
দিবি
affidavit কি দেবো, কোড বলুক আগে।
these are the query. If you don't answer, if you accept my contention, I am on. If you not, the man will decide.
I just make my submissions prima facie because my learned friend has shown me it. My lord, TET was held on 29th September 2022. Just my lord, the list of dates.
Yes.
10th January 2023, provisional answer key published after holding the TET, inviting objections. My lord, typing mistake, clarifications. This should be objections. It should not be clarifications. Type করা। Objections from candidates. My lord, this was done that if you find anything missing, because all are OMR questions, one questions, 4 options. If you find anything wrong in the key answer or the key answer was published, my lord. Key answer itself was published. My lord, several candidates, my lord, raised their objections. I don't know whether they raised objections pursuant to this or not. My thinking, my lord, they didn't, my instant, they did not raise any objection at the first instance. So they accepted that key answer. Then, my lord, after considering the objections, on 17th January 2023, final key answer was published by the board. And dispute and 17th January extending the time. I'm sorry, Malad. Further inviting objections. Then on 19th February 2023, final key answer published after considering objections. Up to this, Malad, nobody raised these questions. So they had the opportunity. Please come and raise this. Then, your lordships, one writ petition was moved on 29th August 2023. But here, your lordships, this court directed the authority, the Honorable Single Judge, the board to take another expert's views or the views of the experts from the board. A 3-member committee was formed by the board. I have annexed that order, your lordships. And that report was prepared by that expert committee. Board is a statutory body. Now, when the report was to be submitted, the court directed you file your report by the learned single judge. You filed your report to the authority. Court appointed an expert before of the Vishwabharati University. Vice Chancellor was directed to form a committee and consider our report and their versions, who are the petitioners. That order we questioned before the division bench. That order should be considered now before the losses. Your losses, kindly take up that order at page, if I'm not wrong, page 87.
Yes.
Now, your losses is a long list order. I will not be taking your losses to that. Only some of the portion, internal page 4. If your lordships kindly come at the after 4 lines at the first blast. Has your lordships got that one? In the internal page, there is no paragraph, your lordships. Starting after 4 lines.
Page 87.
Page 87.
Yes.
At the first blast, we are not convinced at the interim stage with the submissions advanced by the respondents, as we find that the scope and jurisdiction enshrined in judicial review, as succinctly laid down by the apex court in a catena of decisions, does not permit the directions passed by the single bench in the impugned order. But after giving an anxious thought, we find that the several directions were passed at the interrogatory stage by the single bench, which were duly complied with by all the parties, including the appellant. Therefore, we feel it necessary to bring with us to such issue in adopting a mechanism eroding any conception of ambiguity to prevail or may prevail into a large number of students in evaluating such answers. Now, why I am placing this, your lordships? As I told your lordships, my lord, because the learned single bench, whatever said, we complied with. Go to that expert, we did it, take report, submitted. Then ultimately again another is expert. Board, your lordships, is go on and on. Board, my lord, first invited objections. Board constituted a committee of experts of different university and colleges. Then answer keep prepared. Then invited objections. Considering objections, final key instance was prepared. And then it was published and made it final. There must be a finality to it. Then, my lord, because of this, court will say that we will pass this order. What order the court passed, your losses kindly consider. Page 92. Before that, your lordships, page 91, internal page 8 of the order. Your lordships, kindly skip over the first 5 lines, and then, though we feel, your lordships get it. Page 91.
Yes.
Though we feel that the single bench ought not to have ventured deep into the aforesaid aspect, but after noticing that several orders were passed in the aforesaid writ petition, directing the respondent authorities to file a report from the expert on the correctness of the answer keys, which have been duly complied with, and subsequently found that dissenting opinion in this regard and directed further expert committee. Because of this, court Malad did not approve the order of the single bench, but different opinion comes, and your losses several authorities were sent. So appeal bench constitute a 3-member committee. Kindly see your losses. The last 92.
May I come back?
We therefore modify the impugned order to the extent that instead of submitting views, reports, opinions by the board, as well as the writ petitioner independently, the issues can be referred to a committee consisting of 1 member to be nominated by the board, having a proficiency in subject in relation to the questions over which the dispute has been raised, 1 member from the University of Calcutta in the relevant subject, 1 member to be nominated by the Vice Chancellor of the Vishwabharati University, having a knowledge and expertise in the particular subject. We are conscious that there would be a multiple committee as the dispute has been raised on several questions and the answers is given for it. But in our opinion, it would bring a quietus to an issue and percolate a sense of fairness and transparency. The nomination shall be completed within fortnight from the date of communication of the order and the respective authorities. The state will provide all logistic to the members, all that. So therefore, this committee was formed by the Malad division bench. Parties hearing the parties.
The report of which has been challenged in the present writ petition
Is this committee?
Okay.
Now your losses, Malad, primary level. So they said, we are not the expert of that subject. So question relates to somewhat pedagogy. They said some pedagogy members should be there. Then Malad, we mentioned before this matter, before the Honorable Single Judge, because the court said the report should be submitted to the pending writ petition before the learned Single Judge. If your losses will find last paragraph. With these directions, the aforesaid appeals are disposed of. We expect that the writ court to decide the matter on merit after the reports are filed by the committees. Initially, this Honorable Single Judge says, asked me to go to the approach the Honorable Division Bench because this is the order of the Honorable Division Bench. Then we approach the Honorable Division Bench. Then your losses will find the order passed by the Honorable Division Bench at page 97.
Before that, this appeal arises out of which order? Mr. Basu has.
This is not appeal, writ petition. This order.
This-
Now that I give you losses. I have not placed. I'm mistaken. That's, I think, your losses. Page 72 starts. A relevant page will be page 79. Justice Mantha, Honorable Justice Mantha, page 72. We question this order. Justice Mantha sent it to the Vice Chancellor of Jadavpur University, a report, calling for a report, considering our report, all that. Questioning this order, appeal was filed.
Okay.
Now, page 97, your losses will find. May I place it, your losses, 1 or 2 pages order. The minutes of the meeting of the subject expert in English and mathematics are produced. And on perusal, the original are returned to the learned senior counsel, appearing on behalf of the appellants. The subject experts in the resolution have opined that the concerned questions pertain to pedagogy, both in English and mathematics, are to be examined by an expert. So in view of the decision of the expert committee, however, the committee has expressed its inability to decide the concerned questions and recommended that an expert opinion should be sought from the experts in the field of pedagogy in English language and mathematics. We constitute a committee consisting of 1 member to be nominated by the board having required expertise and knowledge in English language, pedagogy, mathematics, pedagogy. 1 member to be nominated by the Vice Chancellor of his nominee of the Presidency University having expertise and knowledge in the field of English and pedagogy and mathematics. This was at their my lord, insist. They insisted somebody else. One member to be nominated by the Vice Chancellor or his nominee of the Jadavpur University having expertise and knowledge in English pedagogy and mathematics. So for these 2-3 questions, another committee was formed. And then the final report was my lord, submitted before the court. My lord, why I am placing it to your lordships? My lord, these are the experts in the subject formed by the court. And then this was submitted. Now, my lord, your losses will find, I will take your losses to the writ petition. This report has not been questioned. If your losses kindly come, then I will take your losses to the, what they are citing your losses today. Kindly come your losses, the prayer portion. My lord, prayer A. Mandamus commanding the concerned respondent authorities to quash or withdraw the report. My lord, mandamus can be asked for, my lord, for to do certain things, not for quashing. Quashing is a writ of certiorari, my lord. Mandamus, my lord, they cannot ask me to quash my own report. It's for your lordships to quash the report. This is a mandamus. There are mandamus means as we have read to command. Do it. They are asking for quashing of the report by way of mandamus. And then second, your lordships will kindly see.
Yes.
With this, at page 40, my lord, prayer G. No report has been asked for quashing in certiorari. It's a vague, delightfully vague. Now, third, my lord, see the audacity of these petitioners. I will take your losses to that. Annex prayer B at page 38. Why this sort of petition is being moved? A writ on the nature of mandamus, commanding the respondent authorities on the basis of potential prejudice and lack of impartiality by removing all the experts from within the state of West Bengal. These experts appointed by the court, they are asking, they should be thrown away from the state. And asking that's mandamus from your lordships. This is the object. A committee appointed not less by the division bench of this honorable court. This is the way of the writ petition and prayer should be couched, my lord. I am not seeing, my lord. And then say, file a report expeditiously. By whom? Whole object, your lordships, to stall the entire selection process in the state. Kindly see prayer C, D. My lord, they have not said, your lordships, file a report by whom? Where they have asked for that. Everywhere your lordships will find that. Now your lordships will find.
Yes.
This is the situation. Now your lordships will find. My lord, my learned friend has placed with your lordship page 199, probably the first. Are আমি ঠিক বলছি তো? 199. Now, my lord, kindly see. My lord, second paragraph. Purpose examination of certain alleged MCQ questions of teacher eligibility test 2022, subject mathematics, serial number 93. Also, question number is of the board. So, this has arrived at by the expert committee appointed by the court after taking exceptions of all. I believe my learned friend has submitted this. Whatever now today they are showing today, I do not find any, my lord, averment to that. The page 268, they submitted before the authority. I do not find that, your lordships. Court said everybody is ready, my lord, filed the objections, whatever they submitted on that particular day before the division bench. The bunch of papers were submitted. I do not find that. Now your lawsuits will find, kindly come to page 268. But what is it? This is an RTI reply. This is not an expert opinion. And first of all, if you think X is an expert, the authority has to treat him as an expert. I lost his get to the point. Court appointed that these are the 3 universities and 1 member of the board. They will consider it. Unless you can show from their report itself that, look, these were before you, but you didn't consider it, and therefore this is perverse. But court should not embark upon it.
Yes.
Now, my lord, kindly look at page 268. What's the contents of it? My lord, this is of dated 6th February 2025.
Yes.
Now your losses will find the division bench order passed by the Honorable Division Bench. I get your losses to that. On just a minute. 23rd August 2024. Page 86. Instead of submitting, somebody wants that X candidate was appointed as the first candidate. What marks did he got? This is an information. This is an information under the right to. Oh, the sun rises in west, the expert committee. Now that's not written here. This is not, this is your lordship judgment one thing, sun rises to west. You have to show that in your pleading that this is such a mistake they have committed. This is not your case. And everything obtained after the committee was over. I'm not wrong, my lord. So kindly see, my lord, page 20, paragraph 29. The above reasoning of the bench the above reasoning of the bench
Yes.
but the above reasoning of the bench squarely applies either to the concept of transparency or for proper exercise of the right to information without the limitation act.
I don't want.
Mal-
I don't want.
Malad, I'm not that. You want, but your prayer I'm placing. Though,
As authority, I am not asking for disclosure. Prayer,
Malad, I'm not on disclosure. What you have prayed in prayer, be kindly consider that. So your whole objection, object is like that. Then I have taken your losses to the.
Yes.
Just a minute, my lord. My lord, I just, my lord, give you losses the definition of information. Under the Right to Information Act. Information means any material in any form, including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data, material held in an electronic form, and information relating to any private body which can be accessed by public authority under any law for the timing in force. This is the information. Now, what is this? These are informations which a body already having in its possession. Suppose your lordships, today, board is having the experts committee's opinion. One can ask for, give me a copy of the opinion. But without disclosing the names, one can ask for. But can it be an information, your lordships? Which answer will be correct? Give me. So this presupposes, your lordship, and this shows that somebody is already on table, my lord, that I will do it. You just give me ask me an information, I will give you in your favor. And you can go to the court with that. Clear to your lordship what I am submitting?
let them.
My lord, please, my lord, not on put. Please, certainly, my lord, please, what I find from it. Because law does not permit it to this authority to give something under the Right to Information Act. Law does not permit this authority. Do you have this opinion of the expert of the board? You don't have. Somebody to form an opinion and give us a right to information under the Information Act. Am I clear to your lordships? You are asking to form opinion by your authorities of a body, and then can you form that's an expert opinion?
Authority.
You are asking somebody.
Asking an authority under respect.
Probably I am not quarreling with my learned friend. My learned friend will have a chance, and then your losses do
I
that.
am not.
All that I'm saying, your losses, this is an information, not an opinion. Neither in information, not an opinion. And who is the expert? My learned friend described this as an expert opinion and based entire submission on this to topple the entire system. Kindly see, your lordships, has been forwarded to head of the Department of Mathematics and Statistics ISS year and question number such and such. And kindly visualize what the division bench did. Division bench said, Vice Chancellor of both the university, who is an educationist, nominate your appropriate professor to do it. Who nominated him? And all these are subsequent. Go on like this. Only one thing I tell you, lordships, I missed it because Mr. Vishwas was not there. The division bench judgment passed by the Honorable Mr. Justice Tandon, presided over by, that was also tested before the Supreme Court, and Supreme Court says a correct judgment. The losses should keep it with the losses. They have not said it. I didn't find it. I will stand corrected. They have not given this information to your lordships.
This was withdrawn.
You done.
Relying on justice conduct.
প্যারাগ্রাফ বলেছিলেন 6
Yes.
But these are my humble submissions for the time, your losses. I'm just taking losses. I will come back with you.
আবার আসবি?
দরকার নেই।
তুমি ভয় পাচ্ছে তো পালা। I have showed to lordship about one. What I have said? I have said that this is the highest authority. One. I have showed only one. Another, all the questions I have also annexed the textbook. Textbook also said so, my lord. I have a judgment of the Honorable Odisha High Court is single bench judgment. My lord, if your lordship allow me to place, there also same thing happened. There also same thing happened. Kindly come to paragraph 31. I will not travel your lordship to the NCRT.
140.
Can report judgment তো দিতে হবে। Recognize reference book that candidates commonly rely upon.
Kindly paragraph number.
31, my lord. There was a similar thing. Expert was appointed. Expert's opinion was challenged. On this context, my lord, can you read paragraph 31? Moreover, the answer key provided by the panel of experts should, as far as practicable, align with the established commentaries or widely recognized reference books that candidates commonly rely upon, unless there exists a compelling ambiguity or a valid reason to deviate. Am I clear to my lord? Examinations of this nature are specifically designed to assess a candidate's knowledge, comprehension, and analytical skill based on widely accepted principles and literature.
Answer exists as varying values proposed. Yes.
If the answer key contradicts some authoritative source, it is not only creates confusion but also undermines the fundamental purpose of the examination. Such discrepancies can unfairly disadvantage candidates who have prepared diligently based on these references and cast doubts on the eligibility and transparency of the evaluation process. From paragraph 17 to 30, pointer to show to the court that these are all wrong. This is Udita
Of course,
Emergency.
we should about the rest of the questions.
All.
Yes, because
ওই আমাকে এইটা দে না।
93 he has objected this is not an information. Then you go to the other, there is textbook.
No.
So we have to find out what are the objections to the questions and the answers, so that we can also give his answers to each and every questions that has.
It is an information, but you have to see who is the source of informing.
Okay, no, I'm not on that point. The point is that in 93, suppose you have got a information from ISAR. Correct.
First of all, now
In 136, the information is got from the Council of Agricultural Research.
they are
Now,
authorities.
this is a Right to Information Act or a textbook of the Agricultural Research Institute? What was that?
These are two for information under Right
So,
to Information Act.
We have to analyze one by one what are the questions and what is the given by the which authority.
এটা correct তো? You kindly take this one and return the other one. এটাই আছে? Now kindly have no, kindly take up this chart. Question number 93.
No, 93 I have heard.
90.
I have seen 268.
This is horticulture. If the planning commission is 131. Authentic answer is
Assessed by the court.
That's I'm saying.
This cannot be assessed by the court. We have to rely on the experts. The experts have been
No, if the experts
Opinion.
and my lord, this is the literature of Ministry of Science and Technology at the top. One will find it. First page I have built.
Okay.
Page 73. In their books, such and such, at some time more than 1 billion years ago, temperature and moisture conditions were suitable for life. There was no free oxygen, but the atmosphere contained ammonia, such and such. To India, author such and such said the authority produced. On the basis of this, Supreme Court decided the answer is wrong. So my lord can deal with this. The university produced the opinion of Sri such and such. We agree with the High Court that though Sri Vision is a knowledgeable person in this capacity, he was evidently under some confusion while giving his opinion. Profoundly sometimes creates confusion in the very opinion sentence such and such why the court was granting. Even there is an expert. In the entire judgment, we will find different question has been dealt with by the court itself. I cannot say, my lord, that Lordship will decide which the correct question would be. I will only show to your Lordship that there is a possibility of wrong answer given by the expert on the basis of the literature, textbook, and other information.
What was challenged before the Honorable Supreme Court?
The Justice Tandon's order.
It's appointment.
Sitting Justice Tandon's order and Justice Tandon's
Appointment of the expert
Yes.
committee. This was challenged, or some other grounds were there.
I don't know. They
Please
are-
find out.
In this matter, my lord, from very beginning they can.
So please find out because the petitioner filed the SLP before the Honorable Supreme Court.
Petition adopt
What
that.
was the ground of challenge to the order passed by the Honorable Division Bench?
I don't know.
They were
Find out.
preferred an
On
application.
15th, we'll place it on 15th.
Why you have filed? But that is been dismissed. So order of Justice Tandon holding the for expert.
Well, I'll hand over the copy of the SLP tomorrow.
দেখে বল না জোসেফ খাটালি
এক্ষুনি আমি কি করে বলবো?
দেখে বল।
Heard Mr. Baptangsu Basulan, senior advocate, appearing for the petitioner. He seeks some accommodation to make his further submissions.
ওপরে দোকানে বই আছে উঠে
জানো গ্রাউন্ডটা মারো জানতে যে গ্রাউন্ড
List. List this matter on 15th. I suppose on 15th you will complete all the questions.
Yes, that is the main thing. I
Ah,
take assistant is a prepared, it is not correct. But this is the correct picture and the pages also
কোশ্চেনটা লিখে দিয়ে আনসারটা কি দিয়েছে তার
and the expert
15th এ রাখুন, 15th.
তাহলে পিটিশনটা ওপেন করতে হবে না
আমরা 15th ওটা নেব তো? Other matters are on 15th relating to the report.
Yes,
So I'm placing this matter also on 15th.
but Malad, in the different Malad, the points are different. Other matter your
We
lordship
have
fixed.
started this, so we'll take it up once after the other.
পুরোনো একটি করতে হ্যাঁ তুমি বললে
Oh, separately.
Mr. Subir Sannal, learned senior advocate. Are you placing this fact? You have given a copy to Mr.
Yes, Malad,
This
we
is
have handed over. Yes, we have supplied.
সেই উপায়
file, sir. List of dates along with document annexed, which has been also handed over to learned advocate for the petitioner. I will list this matter on 15th. Go to the- Thank you. Or here. Oh, take this book. এই বইটা দিয়ে দিন।
My lord will be here.
Yes.
My lord will be here.
Oh, we'll go to Jalpaiguri on 16th. 15th I'll be.
আরে আমাদের তো এখন ইনভাইটই করে, আমরা যেতেই পারছি না তো।
Invite করবে না।
না না, আমাদের ইয়ে করতে হবে বাড়তে।
Bargaining justice Bosak was there. Bar asked
এটা
for
আমাদের।
300 passes.
আর কি আছে?
Justice Bosak, as usual, started from 50 passes. Then going on bargaining. Because SPG is Chief Justice of India, this security is tremendous.
বার ছাড়া কি বেঞ্চ হবে? সার্কিট বেঞ্চ। আপনি তো বারের লিডার, আপনাকে তো আমরা ইয়ে করেছি কালকে।
Transcript
17,
একটা দিন
16
লিখে
তারিখ
দিন।
আমরা থাকবো।
26 আছে। 30 এ যাই।
হ্যাঁ 16 তারিখ কোর্টটা বন্ধ করছে 16 তারিখ কিন্তু কোর্ট বন্ধ করেছে
হ্যাঁ, হ্যাঁ লিখে দাও। নেই মনে হচ্ছে ট্রান্সফার। You take it up on the next date.
Well,
এই একটাই বলছিল তো তো বারে জিনিস